Welcome to the monthly webcast presented by Pro Bono Partnership of Atlanta. My name is Crystal McElrath. I'm at the law firm of Swift Curry McGee and Hires, where I practice in the workers' compensation and employment law practices. Today I'll be talking about the risks associated with misclassifying independent contractors with reference to some guidance from the IRS, the Department of Labor, and Fair Labor Standards Act, and then some workers' compensation laws. The Pro Bono Partnership of Atlanta provides services to local nonprofits, and on this slide you'll see here the criteria for being clients of Pro Bono Partnership of Atlanta. This webcast is for informational purposes only and does not constitute legal advice. We'll take some questions, but please contact an attorney or contact the Pro Bono Partnership of Atlanta for any specific legal guidance. So, jumping right in, we're going to talk just briefly about why this misclassification issue is important. What's at stake? How does it actually impact us and our clients? We'll look first at the Department of Labor's guidance with respect to the FLSA. Then we'll look at some IRS guidance, and finally wrap up with workers' compensation guidance and tests. So why does the misclassification matter? First, workers are classified as independent contractors by the employer, by you, our nonprofits, but may still feel that when their contract ends, they were more like employees. They'll go to the unemployment office or the Department of Labor when their contract ends because the contract was their sole source of income. This raises a red flag for the Department of Labor, and you may find yourself in the middle of some type of hearing process where the Department of Labor is trying to determine that worker's entitlement to unemployment benefits. Similarly, FLSA claims can arise when an independent contractor's contract just ends. FLSA claims are some of the easiest for plaintiff's attorneys to prove. This is even part of their triage when a potential plaintiff comes in the office to discuss a work injury even. I've heard attorneys say that sometimes those are easier to prove than even the alleged work injury or unemployment or an actual discrimination claim, which is what your employee or the former employee may think they're going to discuss. So once it's determined that a person should have been classified as an employee instead of an independent contractor, it's not difficult to find that overtime and back pay were also due to that individual. And now you're in the realm of an FLSA claim. Sometimes those claims even become class actions, and there are others who fall in the same category. With respect to workers' compensation claims, the determination as to whether a person is an employee or independent contractor truly is an all-or-nothing distinction that makes all the difference if there is or is not a compensable claim, and all the exposure grows from there. Then lastly, the IRS, not surprisingly, is often concerned about what revenue or potential taxes they're missing out on. So once one misclassified worker could lead to an audit for all workers, where the IRS may discover that there were many more misclassified workers. For each misclassified worker, the IRS may find that there were lost opportunities to collect FICA insurance or FICA taxes, Social Security taxes, Medicare taxes, or employment taxes. The government would certainly rather that the employer pay these taxes than rely on a worker to pay them. It's easier for them to automatically collect those. And so the IRS is looking at this as a lost revenue issue. In fact, here, just a few statistics, for example, the IRS estimates that millions of employees are misclassified as independent contractors. They've estimated that misclassification of workers cost the federal government $2.72 billion 10 years ago. 60% of that was attributable to misclassified individuals failing to pay income taxes. Another 40% was failure to pay taxes for Social Security and Medicare, as well as federal unemployment taxes. So the IRS is certainly looking to see if we can't correct some of the misclassifications and perhaps fill in some of the deficit in the budget. So let's start then, like I said, with some of the guidance from the IRS. The guidance from the IRS has broken down 3 common law rules, 3 categories which they use to kind of consider whether or not a worker is an employee or an independent contractor. They look very much at the facts, but again, are placing these facts into this analysis and breaking them down into 3 categories. First is behavioral. Does the company control or have the right to control what and how the worker does what the worker does? Financial. Are there business aspects of the worker's job that's controlled by the employer? So that can be expenses, pay, and we'll look more into each of these in just a moment. And then the type of relationship based either or both on contracts and employee benefits. The first 2 of the 11 factor test, as we call it, is listed here on this slide, and both of these go to control, the first of those 3 common law rules I just gave you. So number 1, an employee is generally subject to a business's instructions, whereas an independent contractor is generally not. Then 2, training the business provides. An employee is generally trained to perform services in a particular manner, while an independent contractor generally uses their own methods and their own discretion to decide how to execute their job or how to carry out the work that they've been assigned. Okay, so moving on then to the financial category, there were 5 more factors under this 11-factor test that the IRS uses to kind of assess the financial control here. So the extent to which workers are reimbursed for their business expenses. You'll note an independent contractor is likely to have unreimbursed expenses. That's just part of the cost of the independent contractor owning and operating their own business. As far as the worker's investment, an independent contractor has significant investment in tools or facilities used to perform services for someone else. Again, kind of just part of the operating costs of the independent contractor running their own business. The extent to which the worker makes his or her services available to the relevant market. An independent contractor is free to advertise, to seek out business opportunities, to maintain a visible location, to work in the relevant market. An independent contractor, again, as you're seeing as a theme here, is in their own business. His or her work, his or her services is also their business. So they are free to conduct themselves in the market as an independent business. Number 6, how the business pays the worker. An employee is guaranteed a regular wage, usually on a regular time frame or time schedule, while an independent contractor is generally paid a flat fee on a time or materials basis. An exception might be that sometimes you have attorneys who are independent contractors who are paid hourly, but again, the exceptions are few. These are just the general rules. And then lastly, the extent to which the worker can realize a profit. An independent contractor can make a profit or loss by performing a contract, depending on how materials or time may shake out after the contract's already been executed. So lastly, we'll look at 4 more factors that go to the type of relationship here. This written contract describing the parties' relationship. Labels, particularly in writing, are a consideration, although those labels are almost never dispositive. They are a consideration. The number 9 here, looking towards whether the business provides employee-type benefits. Benefits suggest an employee relationship, and that's just that simple. A lot of times people want to provide a few extra benefits just to be nice, but that grays things up, that muddies the water a bit. The permanency of the relationship. An indefinite relationship, rather than a specific project or a specific time period, will suggest the intent to create an employee-employer relationship. And I'll come back to this a bit later as well. But lastly here, the extent to which services performed by the workers are a key aspect of the regular business of the company. An employer is more likely to have the right to control and direct the activities of a worker who is providing services that are a key aspect of what the business does. So a restaurant that hires a cook as an independent contractor might run into some problems because what the cook does is exactly what the restaurant does. A lawyer hired by a law firm could be a gray area as well. For instance, the law firm is going to hold out the work of that attorney as its own, and is going to be more invested in how that work is performed. So they'll likely try to exercise some control and direct that work. Then you've got employee relationship. So let's look at an example here before we switch gears and look at FLSA. Steve here is a computer programmer, and when he's laid off by Megabyte due to a downsize, and again, remember that I said right offset, that end of a contract is often when you see the question of classification arise, when someone has gone to the Department of Labor looking for employment and somebody feels that the termination was discriminatory, they've gone to hire an attorney. Both the attorney and the Department of Labor are looking and saying, wait a minute, you were an employee, and I think we can get you some more back pay or some other type of benefit here. So now Megabyte had agreed to pay Steve a flat amount to complete a one-time project to create a certain product. It isn't clear how long it will take to complete the project, and Steve isn't guaranteed any minimum payment for the hours spent on the program. Megabyte provides Steve with no instructions beyond the specifications of the product itself. Steve and Megabyte have a written contract, which provides that Steve is considered to be an independent contractor. It also provides that he's required to pay federal and state taxes, and it provides that he'll receive no benefits from Megabyte. Megabyte will file Form 1099 to report the amount paid to Steve. Steve works at home and isn't expected or even allowed to attend meetings of the software development group. Stephen is an independent contractor. This came directly from the IRS's guidance. This was an example that they provided to us, and I just want to emphasize a few things here. This was a one-time project to create a certain product. Steve was given no instructions. So we have no control here. We have a very specified time period. There's a label here in the written contract that goes to the type of relationship. Again, there's no employee benefits to muddle the water here. Steve works at home, which further emphasizes little to no supervision. Steve isn't even expected or allowed to attend meetings. And that's another important thing, that sometimes you can allow or suffer to work a worker. And it's very important to also be clear about the fact that they are not only not expected, but not actually going to be permitted to do other types of employee behavior. Again, Department of Labor or the IRS gives this clear example in their guidelines and says Steve is an independent contractor. I remember when I reviewed it the first time, I got through that first sentence and saw that he was a computer programmer at Megabyte. That kind of raised a red flag for me here about whether he was doing the same type of work as the business. And again, I think that just goes to the fact that no scenario was ever cut and dry 100%. But here you have maybe one factor that might look like an employee, and then you've got 9 more that say he's clearly an independent contractor. So as clear as you can make it in the real life, that's how it works. Let's talk quickly about the Department of Labor and FLSA classifications, because this is what has been shaken up most recently. In July of 2015, the Department of Labor issued new administrative interpretations, new guidelines that specifically said most workers are employees. So the Department of Labor really wanted to shift whatever tests were out there that were unclear in the department's understanding or interpretation, whatever tests were allowing some confusion as to how employers were classifying their workers. So they shifted their tests or analysis from being focused on control to looking at economic realities. So in short, the economic realities test, which we're going to look at now, looks to whether an independent contractor is really in business for him or herself. Again, I've got this test outlined, and we'll talk about each of these 6 factors under the economics realities test. First, is the work an integral part of the employer's business? Think again about the lawyer law firm example I gave you. Is the worker performing work that the employer itself is in the business of providing to the community? Also consider if the work was once performed by employees of your organization before you began contracting that work out to independent contractors. The Department of Labor does not like to see work that was performed by employees being rearranged and reassigned to independent contractors. It raises red flags as to whether or not the business is just looking to avoid paying other taxes or benefits. Does the worker's managerial skill affect his or her opportunity for loss? The Department of Labor kind of rejected arguments that the amount a person makes, profit or loss, is tied to their ability to work fewer or more hours. Instead, they want to see that loss or profit is tied, they want to say that loss or profit is tied to whether the worker uses managerial skills to obtain numerous clients instead of just one. And sometimes the word managerial can trigger supervising a type of thoughts in our mind, and that may not necessarily be key. An independent contractor may not necessarily have to supervise 3 or more of their own employees, but the idea is that they're managing their own business. They're managing obligations to as many clients as they want to obtain and pursue. And if somebody is beholden only to your organization, then perhaps they're not exercising the managerial skills to really obtain and manage numerous clients or to maximize their own profits. The relative investment of the worker and the employer is looking to see if by comparison an independent contractor's investment is relatively minor compared to the employer's. The Department of Labor will probably see an employee if the independent contractor's investment is minor compared to what the organization has invested in that project or in the service that is at issue here. The worker's skill and initiative is, again, looking at the worker's business skill, their judgment, their initiative. So this isn't necessarily about technical skill. It's not even necessarily about certifications or experience. It's the business sense that the worker has when they're operating their own business here. Number 5, the permanency of the worker's relationship, we kind of touched on just a bit with the IRS's guidance. This factor considers the permanency or indefiniteness, but this does not necessarily mean that the worker is engaged in some type of services for years on end. The question is whether the independent contractor knowingly works for a limited amount of time, a set number of projects. So even if the employment was only for a few weeks, even if the engagement was only for a few weeks, you might have a short-term employee if the employee is not clear that they're only working for one particular project. Then lastly here, the employer's control of employment. This goes back to the old standard control. The Department of Labor still recognizes that that's a factor, but they want it to be less significant. It's just a factor of the economics reality test, and perhaps it's even significant that it's number 6 of the last one. But an employee can work from home at his or her own hours with little supervision, whereas and still be considered an employee. So they want to kind of rework how we think about control and how much importance we put on it. Another scenario for us. A worker provides cleaning services for corporate clients. He performs assignments only as determined by the cleaning company. He does not independently schedule assignments, solicit work from other clients, advertise his services, or never endeavor to reduce his costs. He is issued a Form 1099 each year and does sign a contract stating that he's an independent contractor. The company provides insurance, a vehicle for him to use, all of his equipment and supplies for the worker. The company also invests in the advertising and finds clients. Occasionally, the worker brings his own preferred supplies for certain jobs. Let's actually just kind of go through some of these factors step by step and then see where we all think this person lies. Going right off the top, this worker performs assignments only as determined by a cleaning company. This probably shows that they're not out there really advertising or soliciting their own clients, finding their own jobs. We're leaning here towards employee. He does not independently schedule assignments, solicit additional work from other clients, advertise the services, or endeavor to reduce costs. Several factors here that point to employee. He's not scheduling his own assignments. He's not advertising, holding himself out. He's not concerned with his own profit or loss. He's not really running his own business here. He has issued a Form 1099, and he is signing a contract. So there's some statement here in writing. There's a label that points to the type of employee relationship. But remember now, if we're looking at the economic realities test here, that label has less bearing, less importance here. So far, all the factors have pointed to this person being dependent upon that cleaning company to find his clients and to provide him with the opportunities to do what he does. The company provides insurance. That's an employee benefit, harkening back to that IRS guideline here. They're providing equipment and supplies. They're also doing some of the advertising and finding his clients. Those equipment and supplies would indicate, I believe, a pretty strong investment. Likewise, they say the company invests in the advertising. The client's or the worker's investment is simply bringing in his preferred cleaning tools, as he prefers for certain jobs. And that is a relatively minor investment by comparison to what the company has invested. So, I think this is leaning towards employees. Did you guys agree? Did we come to the same conclusion there? How about another scenario? A highly skilled speechwriter has worked intermittently with 15 different politicians and candidates over the past several years. She's highly sought after due to her experience and her reputation in DC, but does continue to still do some marketing. She negotiates rates for each speechwriting job and turns down work for whatever reason as she sees fit, including because she's too busy with other jobs. And for the last 8 years, she's worked for Michelle Obama and has only accepted jobs which do not conflict with the First Lady speaking engagements. Let's go through this one then. A highly skilled speechwriter here. I threw in that word highly skilled as a bit of a red herring because here that skill is pointing more towards her experience with 15 different politicians. Remember that experience and certifications are not as important when we're talking about skill as your business judgment and business acumen. But it looks like she's got a pretty good business acumen as we read on. She's negotiating rates, she's highly sought after, and she's running her own business here. She has developed some dependency on the First Lady to the extent that she's scheduling primarily around this job, but she is accepting other jobs as she sees fit. She's using her judgment to decide to turn down work or accept it around these speaking engagements. So she's using independent judgment, and she is not truly completely dependent upon the First Lady to find work or to provide her with the opportunities or the income that she needs. So this would be an independent contractor. Let's turn our attention lastly to workers' compensation laws. Again, in workers' compensation, the distinction between an employee or an independent contractor is all or nothing. It means that we have the relationship necessary to establish a claim and then talk about XYZ wage and medical benefits, or there is no claim here at all. Again, the statute itself spells out an independent contractor is not an employee and is not brought under the Act, not eligible for benefits. The test is whether the employer, under the contract, be it orally or written, has the right to determine the time, manner, method, and means of executing a contract. So workers' comp is still using control primarily. Time, manner, method, and means of carrying out the work that's been assigned. So I want to jump right into a scenario. This comes right from one of the guiding cases that we use in reference. We had a claimant, which is a plaintiff, but in workers' comp we use the term claimant here. We say a claimant worked with a crew that had no direct supervisor. That was a check in the independent contractor column. The claimant worked for several different drywall contractors. Again, not dependent. You want to think back to some of the other tests we just discussed. Not solely dependent upon one source of income and able to hold himself out as a business. Claimant was paid by the square yard. Again, think back to that IRS test. Not necessarily a regular weekly paycheck, but it's based on the amount of work produced. Claimant negotiated the price with his employer. No withholdings were withheld, so no taxes, no Social Security, no Medicare. All checks an independent contractor. Now, the company did provide materials for the sheetrock work. That might put him more closer to an employee. Then the claimant used his own tools to perform the work, leaning back towards independent contractor. The employer directed the claimant on where to go to perform fill in the blank work, whatever work it was. That's a major check in the employee count column for workers' comp. Sometimes you'll also even see down to the consideration of whether the employee or the claimant was required to wear a uniform, if he was told what time to report, all of these things. The claimant had lots of experience, and that would qualify in workers' comp. That would check as more of an independent contractor, although it's different. Again, I want to emphasize that's different from the experience test that we just talked about under the economics reality test from the Department of Labor. Claimant did not need any instruction or training. The employer retained the right to acquire or request changes to the end product, but not necessarily, let's say to the end product. That puts an independent contractor column. It later does say that the employer was able to require the claimant to start and finish a job in a certain amount of time, or to request changes throughout the process would put him in the employee category. Then lastly, the claimant chose what hours he wanted to work. Start time, independent contractor. So if you're being told how to do your job, when to start, when to leave, what to wear, anything like that, again, method, manner, time of how to execute the work that's assigned to you. Workers' comp is going to look at this very fact-specific, but look mostly to see how much control the employer was executing or exercising over that injured worker when the accident occurred. So I want to wrap up here with just some best practices. just some practical tips that we can talk about and apply for how we want to steer clear of some of the risks that come with misclassification. If possible, choose a flat fee compensation for a project rather than a salary that's paid on a weekly or bi-weekly basis. Contract with specific terms for breach rather than at-will end of that contract. So at-will is something that we hear thrown around a lot in employee relationships. It means that either the company or the employee can simply sever the relationship. It looks more like a contract between two separate organizations, two separate entities, i.e. your organization and the independent contractor, when you simply say, this is what we expect of each other, and if either of us fails to honor these expectations or contractual obligations, then we will terminate our contract. Never engage a former employee as an independent contractor, if possible. This is just a big red flag. If you switch someone from working under you with proper benefits, taxes being paid, and suddenly decide that you want them to do the same or similar work as an independent contractor, you are just going to find yourself in trouble. I would bet on it every time. If you can, don't engage an independent contractor who was an employee anywhere else within the last 18 months. Now, why that? Why should you be concerned about their work history? If they're going out on their own, relatively new, they might not have truly established themselves as a new business. And they might not understand truly what an independent contractor's expectations are. They may just be so new to working as an independent contractor that they're still going to be looking for an employee benefits for overtime, for any type of other factor or benefit that might muddy the water. Now, I said never here. This is probably just something I should say if possible, because we were all starting out at some point, right? But just keep this in the back of your mind. That someone who's brand new to being an independent contractor and just left this job, maybe just calling themselves an independent contractor as a stopgap till they can find their next employer. And I don't want to see you get into some questionable or confused areas because they're not truly operating as a business. They're not truly advertising or holding themselves out to pick up other clients or to really maximize their own profit as a separate economic entity. Again, similarly, I said never be an independent contractor's first customer. Maybe that's try very, very hard not to be their first customer, but never, I would say, do you want to be their only customer. And you certainly want to make it very clear in the contract, at the very least, that they are free to go and find other customers. Maybe you can't control how successful they are in their marketing, but you should certainly be encouraging it. You don't want to ever, ever, ever engage an independent contractor to perform the same work as an employee. It's just that simple. Don't do it. Again, it will look like you're trying to avoid paying the person as an employee, providing the benefits that you're required to provide them under the law. Never prohibit an independent contractor from working for other companies. To my point earlier, encourage them. You may not be able to control how successful they are, but encourage them to find other customers, because otherwise they'll be economically dependent on your organization and they will be darn close to being an employee. You don't want to provide training to an independent contractor. They're running their own business. You're hiring their business. You wouldn't hire a painter to come to your house and expect to have to train them to paint your front door. You don't hire someone as an independent contractor and expect to have to provide training for them on how to do their job. You are expecting them to bring their expertise to you in an area that is separate from what you do. It's separate from what your company's regular business is and separate from what your expertise is. You're looking for their expertise, their managerial skills, and you're looking for them to come and just provide the product. Now, sometimes maybe you have to provide them training on how to use the copy machine in your building. Technology is different here. Minor things like that, yes. You don't need to provide them training on how to perform their specialized trade. You don't want to ever attempt to control how, where, or when they perform the work that you've engaged them to perform. If possible, you don't want to provide all the tools or equipment. Again, there'll be some times where maybe you provide some of it, but again, try to keep that to a minor investment as compared to them making the larger investment in their tools and their equipment. We're not looking to be reimbursing all their business expenses. There may be a few things you may pay for materials, but you're not reimbursing their overhead. They are a separate business. We're not reimbursing the business expenses as a separate business. Don't convert an independent contractor to employee. Just like we don't want to make an employee an independent contractor, you don't want to make an independent contractor an employee. Once you make the independent contractor an employee, you're opening yourself up to questions about whether or not they should have been paid overtime or been provided benefits for that time while they were an independent contractor. You're also opening yourself up to questions as to whether or not you should have been paying unemployment taxes on them while they were an independent contractor. All of those type of things, whether they really should have been an employee the whole time. And then don't make exceptions based on what the worker prefers. They are a separate business. We make business arrangements, but negotiate everything as if you're negotiating with a separate business, not just on whether they prefer certain extra benefits or accommodations. Unfortunately, and again, this is something I see with my bigger-hearted nonprofit clients, no good deed goes unpunished. And so the attempt to just be a good person can sometimes just get you in a bit of trouble in terms of the law and what guidelines and rules we really ought to be abiding by to keep ourselves out of some trouble there. If there are any questions, I'll go ahead and take a few of those now.
Okay, well, I have a question while we're waiting to see if anyone types some questions in, and that is, you talked about, and if you would repeat after I ask you the question, you talked about several different tests for different purposes with regard to independent contractor status. Would it be possible for someone to be an independent contractor for one purpose and not another purpose? And then what are the implications if that happens?
Sure.
If you could try to repeat that, if you would.
So the question was, since we've talked about 3 different tests here, would it be possible to be an independent contractor for perhaps Department of Labor purposes and not an independent contractor for an IRS purpose or for a workers' comp purpose? And if so, what are the implications? Excuse me. Well, it's usually pretty rare to find that someone is going to be an independent contractor according to the Department of Labor and not an independent contractor according to the IRS. So the tests generally overlap just because the factors and the facts are just going to be what the facts are. Sometimes the workers' comp test can be a little bit more lax. A workers' comp judge makes that call on a case-by-case basis, and they may find that a person who was not necessarily very good at business acumen was still an independent contractor because of the amount of control exercised. That's going to be probably the only time you may ever see a judge make a call right there at the time. Because again, there are a dozen judges, they're making these fact-specific calls and they're looking at control still. The Department of Labor and the IRS are on the same page. They are communicating with each other. They are going to almost always find the same types of facts. They will offer different guidance on their independent websites, but they're in a lot of close communication, and those tests are going to look very similar. Their conclusions are going to look very similar, and you won't find much confusion. The nice thing is that for most of your purposes, you'll be dealing with the Department of Labor and IRS much more frequently than you would be dealing with workers' comp, which is why I left that to the end and just offered a few comments on that one. So if you're thinking about this from a day-to-day perspective, you certainly want to be focusing on what the Department of Labor and the IRS have said. Focus on that economics reality test. But maybe also be keeping in mind that not only do you want them to be their own independent business that's not economically dependent upon you, but also keep in mind you don't want to be exercising too much control, because that could be a problem in the rare event you have a workers' comp claim.
Thank you. We do have a question. How do these rules apply to a temporary employee hired as an independent contractor? For example, if someone is hired to fill in for an employee on maternity leave. Please.
Yes. So the question was, how would we apply these tests to a temporary employee who was hired as an independent contractor to fill in for another employee, perhaps as covering for an employee on maternity leave? Well, I think if possible, you might still try to avoid that term independent contractor. It sounds like you've hired a temporary employee here. And I imagine you have concerns about whether or not you need to provide this person benefits for the short period of time while your regular employees on maternity leave. And that's something that you can follow up to get specific legal advice on. But it does sound here that you've hired an employee. And so I say that because you've hired someone to fill in and do the work of an employee. Remember, I said we don't ever want to hire an independent contractor to do what we had an employee do. You have an employee who's out on maternity leave, and whoever fills in and does that job will also be an employee.
And then it looks like that's our last question.
Okay. Well, if you have other questions here at the end, you see we have email for the pro bono partnership. They'll be happy to try to get you an answer, perhaps forward it to me to get you an answer. But reach out to them here at the Pro Bono Partnership of Atlanta. This webcast will be posted on the internet if you need to revisit it and refresh your memory as to anything in the future. It's been a pleasure talking with you this morning, and I wish you all well.